Welcome to Spoken Injustice, where we put the criminal justice system in the dock. Trial by jury, a cornerstone of justice or a relic under siege. In this video, we will explore why jury trials are not just a legal formality, but a fundamental safeguard of democracy. From protecting individual rights to reflecting the conscience of the community, trial by jury is a system worth defending. But what happens when calls to abolish or diminish it grow louder? Let's explore together, as we always do, why these proposals matter and why preserving this pillar of fairness is crucial for all of us. The verdict is clear. Justice is too important to leave unchecked. While we have acknowledged the limitation of jury trials in a video dedicated to jury trials and recognized the potential benefits of modest reforms, such as introducing motivated and reasoned verdicts to better align with the demands of contemporary society, we remain steadfast in our belief that trial by jury is one of the few vital safeguards against state power and abuse. For this reason, we are deeply committed to its preservation. Many of you will also be familiar with our ongoing concerns about attempts to undermine jury trials, such as the introduction of majority verdicts, which we regard as a significant and troubling erosion of the critical institution. It should come as no surprise then that we are outraged by recent reports of government proposal to eliminate jury trials in many cases as a strategy to reduce the court backlog. The proposals don't stop at scrapping jury trials. They go so far as to suggest incentivizing defense teams to encourage guilty pleas. We are not naive about the challenges facing the criminal justice system. Overcrowded prisons and court cases being scheduled as far ahead as 2027 clearly demonstrate the need for change. However, adopting measures such as pressurizing defense team to promote guilty pleas or creating conveyor belt style courts where judges merely call case numbers and move quickly on to the next is deeply concerning and risks undermining the principles of fairness and justice. In this video, we will explore these proposals, address the issues they raise, and discuss alternative solutions that uphold the essential rights and safeguards necessary to protect fairness and justice within the system. So do stay with us until the end to gain all the information to reach your own conclusion. Starting with the news as reported by The Telegraph. Shabana Mahmood, the Justice Secretary, is under pressure from senior legal figures to introduce a new intermediary court comprising a judge and 2 magistrates to replace the traditional jury. They would try cases where offenders faced crimes meriting no more than 2-year prison sentence, such as assault of a police officer while resisting arrest, racially aggravated criminal damage, dangerous driving, and possessing a Class C drug like cannabis. Let's start from the basics, as we always do. Trial by jury is a constitutional right in some common law countries, such as the United States, where the 6th Amendment guarantees it for offences carrying more than 6 months of imprisonment. Or Canada, where Section 11F of the Canadian Charter of Rights and Freedoms 1982 guarantees it for offences punishable by 5 years or more in prison. In England and Wales, trial by jury is not a right enshrined under common law or the Human Rights Act. While some interpret the Magna Carta as recognizing a right to jury trial, particularly in Clause 39, which states no free man is to be arrested or imprisoned, etc., except by the lawful judgment of his peers. In fact, we are told by historians that the phrase judgment of his peers likely referred to decisions made by feudal lords or local assemblies rather than juries in the modern sense. Also, the clause includes the phrase or by the law of the land, indicating that judgment by peers is not exclusive. Similarly, it is sometimes argued that this principle was echoed in the Habeas Corpus Act 1679. However, the Act does not establish a right to jury trial. Instead, it guarantees the right to challenge imprisonment before a court, focusing on protection against unlawful detention rather than trial by jury. And certainly the European Convention on Human Rights does not provide a foundation for a right to trial by jury, as it applies to many European countries with varied constitutional frameworks and legal traditions, including civil law jurisdictions where trial by jury is not a defining feature. Proof that there is not such a right can also be found in various statutes that allow juryless trials, such as, for example, Section 17 of the Domestic Violence, Crime and Victims Act 2004, which provides for trial by jury of sample counts only if certain conditions are fulfilled, with the remaining counts to be tried by judge. Or Section 43 of the Criminal Justice Act 2003, which provided for juryless trials in complex fraud cases, though this was later repealed by the Protection of Freedom Act 2012. Or Section 44 of the Criminal Justice Act 2003, which allows such juryless trials to take place where jury tampering has occurred or is likely to occur. However, although not enshrined as a right, trial by jury remains a long-standing and highly respected tradition. As Lord Devlin famously stated, trial by jury is more than an instrument of justice. It is the lamp that shows that freedom lives. The proposed reduction of jury trials to attempt to deal with the backlog may find traction with those who argue that juries are often unfair and make too many mistakes. This criticism, however, is short-sighted and overlooks the underlying causes of wrongful convictions. In nearly all cases of miscarriages of justice, juries have reached incorrect verdicts due to how facts were presented to them, or more frequently because crucial evidence was withheld from them. Ensuring juries are presented with accurate and complete evidence, alongside clear guidance on the reliability and error rates of technical evidence such as expert evidence, can significantly address these issues and enhance the fairness of jury trials. But why are jury trials so important to us? As we have often emphasized, our goal is to humanize the criminal justice system. Lay participation in the administration of justice is essential to achieving this. Baroness Kennedy expressed this idea far more eloquently, but let us first revisit the historical context in which she made her remarks. The proposal to abolish jury trials for cases carrying less than 2 years imprisonment is not new. A similar idea was included in a report commissioned in 1999 by the then Lord Chancellor Derry Irvine, Home Secretary Jack Straw, and Attorney General Gareth Williams. The review conducted by Lord Justice Auld sought to examine the practices and procedures of the criminal courts with the aim of delivering justice fairly, streamlining processes, increasing efficiency and strengthening their effectiveness while considering the interests of all parties, including victims and witnesses, to bolster public confidence in the rule of law. The report proposed replacing the Crown Court and Magistrates' Court with a unified criminal court divided into 3 divisions. A Crown division resembling the current Crown Court with a judge and a jury, which would handle all indictable only offences and the more serious either way offences. A magistrates division structured like the current Magistrates' Court, which would deal with all summary offences and less serious either way cases. And a district division, a new division consisting of a judge, a district judge or a recorder, and at least 2 magistrates, which would handle mid-range either way cases serious enough to merit up to 2 years custody. In this system, defendants would have no right to elect trial in any of the specific divisions. Allow me a little parenthesis here. Although I know that most of you are legal nerds and well acquainted with these issues, just by way of background for those of you who are not so familiar with the offences types, summary offences are less serious offences which are normally tried in a magistrate's court, such as low-level motoring offences, minor criminal damage, or common assault. Either way offences are those that can be heard in the magistrates or in the Crown Court. If the magistrates decide their sentencing powers are sufficient to deal with the offence, the accused may elect to have it dealt with summarily in the magistrates' court or on indictment with trial by jury in the Crown Court. And finally, indictable only offences are more serious cases such as murder, rape, robbery and conspiracies that can only be dealt with by jury trial in the Crown Court. It was during the debates surrounding these proposals in 2000 that Baroness Kennedy made her remarks, which succinctly encapsulate the importance of what we call humanizing the criminal justice system. On the 28th of September 2000, during the parliamentary debate on the Criminal Justice Mode of Trial No. 2 bill, she stated, "By reducing number of jury trials dramatically, we institute an erosion not only of justice, but also of active citizenship. We talk about the social contract being concerned with rights and responsibilities, and here we have the finest example of just that. That jury tradition is not only about the right of a citizen to elect trial, but also about the juror's duty of citizenship. It gives people an important role as jurors, as stakeholders in the criminal justice system. Seeing the courts in action and participating in that process maintains public trust and confidence in the law. Her words highlight the dual significance of jury trials. They protect individual rights and promote civic engagement, fostering trust and legitimacy in the legal system. So, in our opinion, the proposal is misguided and in any event not a long-term solution, as we will see later. However, proposals also include other concerning measures, though not coming from the government. But before diving into the details, if you're finding this video interesting, please take a moment to like it and subscribe to our channel if you have not done so already. Your support helps us reach a wider audience and allows us to create more content aimed at humanizing the criminal justice system. Thank you. Now let's return to the other troubling suggestions put forward as possible measures to address the unprecedented court backlog. On the 3rd of December 2024, Director of Public Prosecutions Stephen Parkinson told the House of Commons Justice Select Committee that letting the prosecution proactively approach the defense and incentivizing lawyers for early guilty pleas could make a significant dent in the Crown Court backlog. He added, if we can squeeze out guilty pleas at a much earlier stage, we will save 4 hearings. This is especially troubling in light of scandals like the Post Office Horizon, where innocent individuals were pressured to plead guilty to crimes they did not commit. And also in light of what we now know about miscarriages of justice and their link, amongst others, to incentivized guilty pleas. The Evidence-Based Justice Lab, an interdisciplinary research group funded by the UK Research and Innovation, have carried out work in this subject. They say our work examining guilty plea decision making in adults has shown that many factors other than factual guilt can lead or even pressure defendants to plead guilty. These include the ability to avoid custody by pleading guilty where a custodial sentence could be imposed at trial, the time and money involved in a full trial, and the ability to obtain charge discounts. They add, as a result of pressure to plead and the variety of considerations that can be important to defendants making plea decisions, innocent defendants do plead guilty. Generally, our survey results suggest that a non-trivial proportion of defendants who plead guilty are or may be innocent. The graph below shows data from one study in which we interviewed 90 legal professionals and asked them to estimate the proportion of defendants who plead guilty but are actually innocent. You can pause the video here and take a look at the graph. It is self-explanatory. Parkinson concluded that if we don't start doing things differently, the problems are just going to get worse. We fully agree with this sentiment. There is no question that given the dire state of the criminal justice system, reform is both inevitable and necessary. However, we have consistently argued that any reform must adopt a comprehensive 360-degree approach addressing the entirety of the criminal justice system rather than focusing solely on the courts. For reform to be truly effective and enduring, efforts must prioritize reducing the number of cases that reach the courts in the first place. Tackling issues such as overcriminalization and the misuse of the criminal justice system to advance political agendas and policies is crucial. critical and requires urgent attention. We explored the current challenges within the criminal justice system in detail in our video, A New Era for Criminal Justice, Preparing for Change, linked in the description below. In that video, we emphasized that achieving meaningful long-term solutions to issues such as court backlogs and prison overcrowding requires a comprehensive reform focused on 5 key areas: preventing crime, considering prosecution only as a last resort, prioritizing diversion, reforming offenders, offering comprehensive support to victims while also educating them and the public at large on the benefits of rehabilitating over retribution, and enhancing accountability of those who administer justice. I highly recommend you watching that video. It's filled with valuable information and may take more than one sitting to fully absorb, but it's well worth the effort. Understanding the radical changes needed in our criminal justice system is crucial to avoid finding ourselves in the same position a few years from now, after implementing risky measures that undermine safeguards and limit full public participation in the justice process. This concludes our session today. As always, don't forget to comment, to like and subscribe to be part of the change. Join us again as we sit and rise in this unique trial.